Hello, my name is Zach McGee. I am the chairman of New Media Legal Publishing, the sponsor of the CLE program you are about to watch. This program was recorded a few years ago, but we've confirmed that the content is still current and reflects the present state of the law on this topic. I hope you enjoy it.
Hello, my name is Peter Afrasiabi. I'm a litigator with the law firm of One LLP with offices in Newport Beach, Del Mar, and Beverly Hills. Today's continuing education program contains only my views, so hold only me accountable, please. Our topic today, sex, drugs, and rock and roll. An overview of intellectual property law with a focus on these lifestyle industries and the legal changes that they are creating for the intellectual property world. Let me stand and deliver in the beginning and tell you what this is not about. You're not going to hear a confessional from a lawyer who had sex with a client while on drugs at a rock and roll concert. That's not what the program's about. If you want funny or tragic such stories, you probably should listen to some of the comedy CLEs, which are fantastic in terms of dealing with that subject matter. We nonetheless are dealing with very, very interesting subject matter, so stay tuned. We're going to start with an overview of intellectual property law, and we're going to look at really the intellectual property stool, which has three legs, of course: copyright, trademark, and patent. And so for general practitioners, this is a great overview of intellectual property law, which facilitates issue spotting for your clients. For those of you experienced in intellectual property law, or perhaps one of those areas, it's a good refresher overview. And after we have done the overview of IP law, we will move to these industries of sex, the adult porn industry, as commonly referred to. We'll turn to different aspects of that industry and how copyright, patent, and trademark law have, the boundaries of those legal areas have been pushed by this modern industry. We will also look at the area of drugs, more specifically medical marijuana, and the massive changes that are occurring in the intellectual property area because of advances and changes in the law in various jurisdictions with respect to medical marijuana. And finally, of course, we'll end with rock and roll, and we will talk about some modern fascinating cases involving copyright and plagiarism, pushing the boundaries of copyright law. We'll talk about the famous Led Zeppelin Stairway to Heaven trial that you've probably heard about. And we will end with a fascinating look at what is occurring coming out of the rock and roll industry with respect to trademark law and the most significant United States Supreme Court trademark and First Amendment appeal in at least a generation, which was just argued earlier in 2017 involving the band named The Slants. That's where we will start. So if we turn to our first slide, although we're not going to get heavily into the propriety of sex, drugs, and rock and roll, it is worth talking briefly about a quick little detour. Just a reminder, sex under the professional responsibility rules, the rules are pretty clear. Really don't do it with clients. That's the safest advice. Abstinence is the safest way to go when it comes to sex and your professional responsibility rules with relation to your clients. Drugs, it's fascinating actually as a footnote. At least in California, there's no specific rule that prohibits the use of narcotics or drugs. But many, many rules are impacted, such as your obligation to act competently, to keep your client updated, to withdraw if you have emotional or psychological or physical conditions that are interfering with your capacity to practice law. And of course, illegal drug use can lead to criminal convictions, which may cause you to get a knock on your door from the state bar. So quick detour advice when it comes to drugs. Again, abstinence, don't do it if you can avoid it. Finally, rock and roll, do it. Many, many lawyers are in rock bands. They have a great time. Justice Ginsburg, as you know, sings in opera, so music is great and it's open to everyone. So with that, let's get started on our IP overview. We're going to start with copyright. Copyright is a creature of federal law. It protects original works of expression that are fixed in a tangible medium. Now, there is no mandatory registration requirement to have a copyright. If you create an original work and you fix it in a tangible medium, you own a copyright at that specific moment. Before we get into originality and fixation, it's worth talking briefly about this federal law on copyright and where it comes from. It comes from the Constitution, of course, and the Constitution has a provision in it that allows Congress to pass laws to facilitate the promotion of the science and the arts, but also to secure to authors just rewards for their creations. And those two overarching principles define the metes and bounds, so to speak, of all of copyright law. And the two are often in tension, and as we will see a little bit later as we look at the lifestyle industries and how they're pushing the boundaries of the law, we'll see how these two principles, securing authors their just compensation on the one hand, but also promoting the development of the field and the arts by other authors and their ability to build on the original creator's work. We'll see how those two come into tension sometimes. But that's the balancing of copyright law that's required as judges and litigators work through copyright legal issues. Before we get into originality and fixation, it's also worth pausing to mention there is no registration requirement, but if you have clients who are creating copyrighted materials, there's a massive, massive benefit to registering. And this is sort of the first practice pointer that we can stop at in terms of general advice for your clients. If they create copyrighted material, they should spend a very nominal fee to register it. It's $55 or so with the Copyright Office. You don't even need a lawyer really to fill out the forms, although a lawyer can do it relatively cheaply. Here's the benefit. If you register your work and then after registration the work is infringed, you're entitled, when you want to sue, to get statutory damages of up to $150,000 for willful infringement and your attorney's fees. The contrary world is if you don't register and someone infringes, you can still sue, of course, although even then you have to actually register before you file suit, so you're having to register anyway. But you don't get the statutory damages and you don't get the claim to attorney's fees. Instead, you get your actual damages. And so as a practical matter, what this means for many a client is that if they have a registration, they can go to an attorney, they can find a law firm who's willing to take the case on contingency, because even if the damages are small, there's this claim for attorney's fees and a claim for statutory damages. And so those act much like the attorney fee awards in the civil rights area. They attract attorneys to the area, which allows attorneys to take cases and remedy a wrong. If your client has not registered, however, when they go and speak to an attorney will happily take the case, but they'll need a retainer and an hourly fee, and the damages may often be less than the cost of even getting a little way into litigation, which means it's often impossible to remedy the infringement of one's works. So if you leave with anything on the copyright front, leave with that. It's worth registering anything that your client perceives as being valuable that may be infringed. Let's turn to originality now. Originality is a very, very low standard under the law, and as you see on the quote here from Justice Holmes on the next slide, it says, "It would be a dangerous undertaking for persons trained only to the law to constitute themselves final judges of the worth of pictorial illustrations outside of the narrowest and most obvious limits. At one extreme, some works of genius would be sure to miss appreciation. At the other end, copyright would be denied to pictures which appeal to a public less educated than the judge." That is from the case of Blystein versus Donaldson Lithographic Company. It's from 1903, but it's still the law today. Copyright law has a very low bar to originality. Only the most minimal creativity is required. Courts like to stay out of the business of mediating whether or not one's work qualifies under the copyright law as being sufficiently original. So if you're watching this program and you're doodling some nice flowers and shapes on a piece of paper right now, you've probably got a copyright right now at this moment in your doodles. Congratulations. The next requirement we turn to, as we see on the next slide, is fixation. And fixation simply requires that it be fixed in a tangible medium. In other words, you need some sort of permanent recording, permanent recordation. So you put pen to paper as you're doodling right now, you've now fixed your original ideas on the paper. If you record yourself singing your new song to yourself, you've recorded it permanently by the act of recording it. If you code some source code or software in a computer, you've recorded it. You draw, you mold some clay into a sculpture, you have permanently reduced to physical form your creation and you have a copyright. So the limits here are the obvious ones. If you come up with the greatest poem of all time and you stand on a street corner and you broadcast it to the world, and this poem only exists in your head and now it's just spun out into space, you don't have a copyright yet. Or if you get a skywriting plane to write it in the sky and it shows up in the sky and then disappears as your loved one reads it, no copyright yet. So record it first. As we move to the next slide, we can look briefly just at what types of subject matter fall within the realm of copyright. And these, as you will see, touch all areas of content creation, and it's relevant to your clients in all the different areas that they may have business. Of course, it covers books and other writings, it covers music, it covers film, photographs, artwork. And by artwork, not just high-end, highbrow, sophisticated art, the masters of oil paintings and the like, but there's even been much litigation, and our firm has litigated heavily over issues of graffiti art that sort of modern form of art done on public buildings or on private spaces even, and the protection of that as art. So art's very, very broad, and it doesn't belong only to the highest brow of creators. Software and source code also has copyright protection, and this is an area that's very, very important in the modern world, and where you want to make sure that your copyrights are protected and you really do get registrations on your software and source code in order to have viable remedies at stopping people who may infringe. Architectural works also receive protection in this day and age, as do pantomimes and choreographs, of course. And just in the last year, early 2017, the Supreme Court handed down a decision in the context of clothing designs, specifically some cheerleader designs, and really opened the door to greater copyright protection for certain design elements and attributes and flourishes on clothing, notwithstanding the generally functional nature of clothing. So copyright, the point being, is very, 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 very broad, and it touches all industries. Good to watch for your clients, regardless of what industry they're in, and think about whether their website content, their marketing materials, the underlying content that perhaps they sell in whatever form it is worthy of copyright protection and can be looked at to get some protection for them. That's the first leg of the stool, and we now move on the next slide to trademark, this being our second leg of our intellectual property stool. The question, of course, is what is a trademark? Well, trademark is a common synonym for a brand name. So the most obvious and famous examples are things like Coca-Cola, 7-Up, Chevy, Google. It's the name of the company, the name of a brand, and it receives trademark protection. Now, trademark protection, fascinatingly, is not just limited to words. It covers sounds, it can cover numbers, shapes, even smells. The most famous sound example, of course, is Ferrari. Ferrari has a trademark on that unique sound that the Ferrari engine creates. So every time you're on the road, you're riding your bike, you hear that roar of an engine, and you always know instinctively it's a Ferrari. You look around and there goes a fast, red, beautiful car. It's because Ferrari has trademarked that sound, which means Lamborghini and Lotus and all these other supercar companies have to come up with their own sound, and they need to make sure they don't mimic the sound in their engines. And so car companies go to great lengths to, especially the supercar companies, to have a unique sound that they protect, and they make sure others don't copy it. A trademark must connote ultimately and be reflective of a given company's goods or services. In other words, a trademark is a source identifier. It needs to be a word or slogan or brand that connotes a product or service with one particular source of origin, and it's the bridge between the two, so that the consuming public, when they go out and purchase a given product or service, they see a name, they can associate that with a single source, and that single source can in turn maintain brand control, quality control, and sell to the consuming public something that does not deceive the consuming public. Trademark law has extended, however, beyond simply brand names and slogans. And this is a very important practice pointer, again, our first major one in the trademark area for you and your clients. Trademark law in our modern age extends to product packaging and also certain non-functional features of products. This is known as trade dress protection. And so your client may well have some sort of a product that is worthy of trade dress protection. For example, the famous Herman Miller chair. It's a chair and it's functional like all chairs, but the unique design shape to the Herman Miller chair has been found to have trade dress protection, such that other companies can come along and of course make a chair, but they can't make a replica of the Herman Miller look and feel, the design, so to speak, of that chair. And that can be protected under the trademark laws, this subset known as trade dress, even absent the securing of a patent or even the registration of a trademark or even the registration of a copyright. The final point to know as we do this quick overview of trademark is that, like in the copyright realm, there's no registration requirement. Just as with copyright, you have a copyright the moment you fix your original thought to paper, the trademark laws are similar. You have trademark rights the moment you use your trademark in commerce. Trademark rights attach, and you don't have to register anything with the federal government. But just like in the realm of copyright, there is excellent manifest benefit to registering a trademark. If you navigate the trademark prosecution process and you secure that trademark for your goods or services in the space your client does business in, then you have a national footprint and you have protection. You've sort of laid down your chips, so to speak, and your marker for your brand, and that gives you the ability to make sure that other people in other states, if they start copying you, you can stop them. Absent that, you do have common law trademark rights, but they are limited to sort of the geographic space and nature of how and where you've been doing your business using this non-registered mark. So as we move to the next slide, we can see again that the focus of trademark law fundamentally is quality assurance. It's to protect against consumer confusion, to act as a symbol of goodwill of what this product and service is, which is sometimes referred to as commercial magnetism. What kinds of trademarks are there? Well, there's basically a hierarchy, and we can look at it as being generic, descriptive, suggestive, and arbitrary, or fanciful. Fanciful being even slightly higher than arbitrary. Let's start with generic. What does generic mean? Generic is simply the actual name of a product or a service. So if my law firm is called 1LLP, but if we just decided to call ourselves lawyers or a law firm, that wouldn't be deemed generic under the law, and that's not entitled to any protection. It's simply the actual name of what it is that one is doing. As you move up this ladder, so to speak, you get to descriptive. And descriptive marks are entitled to trademark protection with a showing of secondary meaning. And a descriptive mark is really just that, it's descriptive. So perhaps you would say a copyright litigation law firm. That's descriptive of what you do. It's not really generic anymore, but it is descriptive, and so the law will give it minimal protection upon showing that the consuming public has come to identify that descriptive brand with a source. As you move up, you get to suggestive, and suggestive has proper full trademark protection. A suggestive mark is one that takes a couple of mental leaps, or a mental leap, to get from what the mark says to what it's referring to. And so an example, if we continue riffing on this law idea, would be sentinel law. One hears sentinel with law, you make one or two mental leaps from the word sentinel, and you get to the idea of, it means to protect or to guard, and then you go, yeah, lawyers guard and protect people and their rights, and so it's evocative in that sense and suggestive of a law or a law firm. And so a suggestive mark receives protection. The highest protection goes, however, to arbitrary or fanciful marks. And an example of an arbitrary mark would be my law firm. Our name is 1LLP, so we are taking a word, a common word, one, but using it in an entirely arbitrary manner as a designator of legal services. And so that's an example of an arbitrary mark. Fanciful is really even higher. It would be a word such as Exxon, where there's quite literally no meaning to that word apart from its function as an identifier of the Exxon oil or gas company. As we now move to the next slide, we are on patents, the final leg to our intellectual property stool that we will talk about in our overview today. And patents exist for really functional achievements, for new inventions or new ways of doing certain things. They cover new, useful, and non-obvious material. And so that's sort of the trifecta. It must be new, useful, and non-obvious. But what's important here, and this is sort of the first practice pointer for you as you talk to your clients in the patent realm, is that it doesn't have to be a breakthrough, the world is going to change type invention. The patent laws aren't designed only for that. I mean, quite the contrary. Most patents are issued on incremental advancements over the pre-existing art that's out there, where different art components of different inventions or devices and whatnot are put together in a new way with something new, and it's a building process upon existing prior art, but with a new flourish to it. That's entitled to protection. And often I've found, and lawyers in my firm have found, when they speak to especially sort of engineers and mechanical device type companies, the engineers often think, oh, what I've done is no big deal. It's different and new, but it's just based on stuff that's been out there, and don't perceive what they've done as being worthy of a patent, but really it is. And this public perception in part comes because non-lawyers often associate patents with things such as the light bulb or the car, sort of these radical breakthrough technologies when they first occurred. And so that's just not the case. So be on the lookout for clients who may have come up with a new, useful, non-obvious invention or product or a device, or even business methods are entitled to patent protection in various circumstances. Now, patent's one area that's different to trademark and copyright when it comes to federal registration requirements. The patent area is one that there is actually a mandatory registration process. One cannot have a patent unless it's been issued by the federal government to you. There's no state patent protection, there's only federal patent protection. And so you must, unlike copyright and trademark, start a process with a patent prosecutor, really, given the complexities of the process, and navigate this process with the Patent Trademark Office. And it's a process that can take time for your clients and an investment of far more money than one would have to invest in the copyright realm, which is $55 or $100, and trademark maybe $750, $1,000 to get a trademark. The patent costs just alone to the patent office can be several $1,000s, and legal fees can be several $1,000s too. So you can quite easily spend $7,000, $10,000, $15,000 on a patent as you go through this complex process of disclosing to the patent office what it is that you've invented, showing the patent office the prior art that you're aware of, and then there's a long back and forth process with an examiner who works for the federal government, who's specialized in your area and who goes and does his or her own research and finds prior art and patents and challenges your assertions that you've come up with something new, novel, or non-obvious. But at the end of it, you get a solid monopoly for a substantial amount of time, which allows your clients to exclude others from entering that space of that patent. Finally, a subset of patents are design patents, and design patents function somewhat similarly in terms of approach to what we talked about earlier when it comes to trade dress protection. And so one example where you see myriad issued design patents for the ornamental design or look and feel of something is, for example, in tire tread. There are hundreds of design patents that have been issued to the different tire companies for the design of the tread of a tire. And the assertion one makes when they get a design patent, of course, is that this is new, novel, non-obvious, and also that it's not functional, because design patents shouldn't be protecting purely functional attributes. But the actual two-dimensional design of a tire has been issued many, many times in a design patent. So that's an example of an area where you may not be able to get necessarily full patent protection on a tire, but you could think about a design patent protection, or you can think about trade dress, as has been litigated extensively also. That brings us to the end of the quick overview of intellectual property law, and we are now going to turn to the sex, drugs, and rock and roll component of this presentation, and we will start by looking at the adult industry. And as we look at the adult industry, and on this first slide, we're going to talk about trademarks in the adult industry. And the question being, can you trademark matter that is deemed immoral or scandalous? As you can see on this slide, in answering the question whether one can trademark matter deemed immoral or scandalous, the standards that emanate from the governing rules and guidelines from the Trademark Office and from the case law are as follows. To be considered scandalous, a mark must be, quote, shocking to the sense of truth, decency, or propriety, disgraceful, offensive, disreputable, giving offense to the conscience or moral feelings, or calling out for condemnation, end quote. This is in the context of the marketplace as applied to goods and services for which one is trying to secure their trademark. What's also relevant is that scandalousness is determined from the standpoint of not just or necessarily a majority, but a substantial composite of the general public, and in the context of contemporary attitudes. That comes from a Fed Circuit case and from the Manual of Trademark Prosecution. Another way to frame this is that evidence that a mark is vulgar is sufficient to establish that it is in fact scandalous or immoral and therefore not entitled to registration on the principal register with the federal government. And courts have indicated that one can go to the dictionary even to find evidence as to whether a mark is deemed vulgar or whether the meaning of a mark is vulgar, and that therefore that the applicant's use of a term is clearly limited to an alleged vulgar meaning. As we turn to the next slide, we can see some examples of trademarks on sex or sex-related words and the disposition of them by the government. So the first one was the phrase, quote, no FUCKS given for t-shirts, hats, or clothes. So the space was t-shirts, hats, and clothes. The mark was no FUCKS given, and I won't pronounce the F word, but we all know what it is, of course. But the trademark sought to actually get the whole word, not the spelling of it as I just did for you. And that was denied by the government, by the Trademark Office, as being scandalous and immoral and vulgar and not susceptible to trademark protection. The next example was one where one tried to secure a trademark for alcoholic beverages, and the mark being FUCKU, the not spelled out, of course, again, but the common word that we've all heard many a time as used. And that was denied by the government and was not pursued any further by the applicant. And so the standard quote that comes from the Trademark Trial Appeal Board, the internal administrative appellate body that adjudicates these cases, is as follows. The fact that profane words may be uttered more freely in contemporary American society than in the past does not render any such words any less profane, end quote. And so that is sort of a good shorthand explanation for why those marks, as you can see in the bullet points on the slide above, were denied, notwithstanding the common nature of those terms in our modern vernacular. Some other examples are the mark Bull SHIT, which was sought to be used for handbags and other personal accessories, and that was deemed scandalous and rejected. And then one person tried to register in the space of spray can gag gifts the mark ASS Whole Repellent, and that also was rejected and denied as being scandalous and immoral. That's the current state of these marks in those types of spaces. Now, all of this is on the line as we stand today, given the nature of some significant litigation that we'll get to on the back end of this program in terms of offensive, demeaning, scandalous marks in the context of a music band. But for now, this is certainly the state of the law, and it should be understood to be the state of the law. So as we move from the trademark realm in the sex industry, we can now start talking about the copyright realm and the interplay of copyright and criminal laws. And this is significant if you have any kind of clients that are in the adult industry. And in this day and age, one may have a client in the adult industry and not even realize it as much as one certainly knew it back in earlier days. And this is because of the internet. And the modern internet world allows for websites to host and broadcast a whole variety of content, including, of course, adult content. And so adult content is no longer simply disseminated and distributed to the public by the companies that in the first instance film the actors engaged in sexual intercourse for movies. Those films are made, and then the content often is burned or ripped or put online by someone else, and then perhaps someone else takes it and uploads it to a general purpose website. And that website then is rebroadcasting this content and may or may not confront a whole host of copyright and criminal legal questions. We'll start in this part one of this discussion by looking at kind of the criminal overlay to this. And the practice pointer here for you to note is that when you have clients in the adult content space, you need to be consulting criminal lawyers and the criminal code to make sure the significant criminal overlay that sits on top of the adult industry as they create their intellectual property in the video content they're filming, to make sure that criminal overlay is not missed. And this is a criminal rule coming, as you see on the slide, from 18 U.S.C. 2257. It's a federal criminal sort of documentation and labeling law requirement. And in short, people who make, broadcast, publish, republish, disseminate adult content need to label that content with some labeling that they have complied with these laws and that they're possessing and holding documentation proving and verifying the age of the actors in the movies. This appends to the creators of the content, and they must maintain a custodian of records with these documents. So the modern internet age has raised a whole host of new questions, and this gets to the intersection of copyright and criminal law in pushing the boundaries of those areas in the adult space. And that is, what happens when the content is being copied and then placed on internet tube sites? This is the Ventura appeal that's pending in the Ninth Circuit Court of Appeals, and as a full disclaimer, my firm was involved in that case. I argued it in the Ninth Circuit and represented the plaintiff appellant, an adult content company, who had sued a tube site company. And so a tube site company, which is important for part two of this presentation on copyright, but a tube site company is a company think YouTube. It's a neutral website that just posts and publishes anything and everything that the consuming public uploads. So whatever video you want to upload, they simply recast it, reformat it, and boom, they publish it for the world to see. And so the question raised in this appeal to the Ninth Circuit was whether, when you have a porn tube site, an adult tube site, so to speak, that is rebroadcasting and republishing adult content, whether the criminal labeling laws and documentation laws that append to the original distributor of the content also apply to this secondary distributor of the content as it distributes the content over its hosted web servers through its URL on the World Wide Web. And we lost in the district court. That case was argued in the Ninth Circuit. I argued it in 2015, and we're now over 18 months later in 2017, still no decision, so I suspect a decision will come any day. But it's a very, very important case raising those questions, and those questions have been raised and litigated in other circuits too, and the law is evolving and murky in this area currently. But what it highlights for you, if you're representing any companies that are hosting adult content or may host adult content unwittingly or intentionally for profit on the ad revenue, that there may well be a criminal overlay here that one needs to look at. Now, these tube sites, we get to part two on the next slide, because it raises a whole host of copyright issues too. And this is where copyright law is being pushed heavily by the adult industry in the nature of what constitutes infringement. And so in 1998, Congress passed the Digital Millennium Copyright Act. And this was essentially designed to allow online service providers to maintain a level of immunity from the strict liability tort of copyright, because by definition, if providing a hosting platform for a website or even the cable that literally the content runs down, as these common service providers are providing the facilities of communication to the consuming public, they're technically tripping copyright all the time because they may be reproducing others' works, and copyright's a strict liability tort. So some safe harbors were created, and one of the safe harbors was known as 512C under Title 17, Section 512C, which generally provides immunity for a service provider for the infringement of copyright on its website if the material is uploaded by a member of the consuming public and the company is essentially hands-off neutral to that content and doesn't engage in editorialization of the content. And so you can think YouTube, for example, where in a seminal case in the Second Circuit, YouTube was held to be worthy of securing this immunity from copyright infringement for whatever infringement may be occurring on its website, simply because consuming public uploaded stuff, YouTube had software that automatically converted the videos to a format that could be then broadcast on YouTube, and YouTube itself was essentially hands-off in this process. And so that enabled it to get immunity. Similar decision in the Ninth Circuit. But in the last 10 years, there's been a lot of significant litigation that has pushed the boundaries of what level of immunity, if any, one is entitled to when they are more engaged and involved with the content on their so-called tube site. And so that Ventura case I alluded to in the adult space raised exactly those issues as we litigated it, because you have modern internet businesses that aren't just accepting anything and everything that the public uploads, and they're trying to curate and editorialize and create niche websites with specific kinds of content. And so that raises big questions under these immunity laws about whether they are in fact entitled to immunity. And so the general rule, that as a practice pointer that you can walk away with for your clients, is the less involved your website client is with the content on its site in terms of reviewing it, deciding whether to allow it to be published or not, editorializing it, getting rid of certain content to create a very specific niche content site. The less your client does that, the more likely they are to have immunity. And conversely, the more a client is involved in the act of editorializing and curating the content that's delivered to it by the public, but the more the client engages with that content to filter out lots of content, to narrowly create a website based on certain of the content, the more likely the client is to lose immunity. And that's the seminal case of Mavericks Photographs versus LiveJournal, a case in full disclosure. I also argued in the Ninth Circuit recently, where the Ninth Circuit held in a large published decision that those kinds of behavior by a website company that's heavily involved in the decision about what to publish on its site and what not to publish, even if the content's originally delivered to it by a member of the consuming public, in fact causes it to potentially lose immunity, or at least to be subjected to a jury on the question. So that's an important practice pointer for clients in the content space on the internet, especially in the adult space, if you are participating in that content. The root thing to remember, be aware of our criminal laws. Now, as we stay with the adult sex industry, we can move to patents. And the question is, can you get a patent on matter that may be deemed immoral or scandalous? We've seen there are some trademark problems there, but do we have similar problems in the patent realm? And the answer, it turns out, is no, we don't. Now, in the old days, we used to, and there used to be a doctrine called the moral utility doctrine, and you see it here from a case known as Lowell v. Lewis, and this was written in the 1800s by Justice Story, and the famous quote from him was that the invention should not be frivolous or injurious to the well-being, good policy, or sound morals of society. The word useful being the litmus test in the Patent Act for what you can get a patent on, the word useful, therefore, is incorporated into the Patent Act in contradistinction to mischievous or immoral. For instance, a new invention to poison people or to promote debauchery or to facilitate private assassination is not a patentable invention. That was, for a long time, the touchstone and litmus test for patentability. Now, it's no longer the law, and the Juicy Whip versus Orange Bang case is the sort of perfect example of a case from the Federal Circuit Court of Appeals that sounded the death knell of this moral utility doctrine. And in that case, a party wanted to get a patent on a device, and the device was fundamentally one designed to deceive the public. And it was one of those devices where you've probably seen such things at the mall, where you go to buy a drink and you see this stand in front of you of all the swirling lemonade and the juice and all that stuff, and you say, oh wow, look at that, yeah, I want a fresh lemonade. And they pour you a lemonade, and it turns out the lemonade actually doesn't come from that swirling machine. The machine is designed to make you think you're getting something just like that, and it lures you to it. And so that was sort of the invention. And the district court invalidated the patent, saying this is just an invention designed to deceive the public, and it falls under this, moral utility doctrine. But the Federal Circuit said no, and the Federal Circuit, as you see in the quote here, said that there's no basis in Section 101, and that being the patentability code section in the U.S. Patent Code, to hold that inventions can be ruled unpatentable for lack of utility simply because they have the capacity to fool some members of the public. And so the result of this is that if you have clients in the adult industry space, yes, they can get patents on their sexual devices or sexual inventions. Now, there may still be a bit of a problem in terms of the actual language used or some of the drawings if they are perhaps too offensive or debaucherous, so to speak, but the patents are certainly able to be secured. And I don't have any pictures of them here because it's probably outside the scope of this, and we don't necessarily want to show such patents, but you are free to get on Google, and if you just go to Google and punch in sexual device patents, you'll see a whole array of fascinating devices that people have secured US patents on. So let's move from the sex industry to the drug industry, and here we're talking, of course, especially in the beginning of the 21st century now, about medical marijuana. It has been legalized in many, many jurisdictions for medicinal purposes. It's being increasingly legalized for recreational purposes, and this is occurring in various states, but it is not occurring at the federal level, where the sale and transportation of marijuana is still a federal crime under the Controlled Substances Act. And so the question has been raised as we now go from medical marijuana and drugs into the trademark leg of our intellectual property stool. Can you get a trademark if you are a medical marijuana dispensary on, for example, some given strain of your marijuana that you're selling under state law through your state dispensary? And for a while, the Patent and Trademark Office had proposed a classification that would allow trademarks for processed plant matters, as you can see, medical marijuana. But because this is illegal under the Controlled Substances Act, in other words, it's literally a crime to sell and transport marijuana under federal law, the Patent Office abandoned the proposed classification such that as we sit here today, you cannot receive a federal trademark for medical marijuana, for the strand of your medical marijuana. So this is a bit of a dilemma if you have clients who are in the medical marijuana space under state law, but a practice pointer for them would be to look to their state trademark laws and state trademark registration vehicles, because the state trademark vehicles may well provide a basis to at least secure a state registration of that trademark. They can put down their chips, so to speak, on that, get the protection for the use of the mark in at least the jurisdiction where they're selling legally under state law, and they can then hope for the day that perhaps things change under federal law, and then they'll be able to go and get their federal mark. That's the practice pointer. What this means, of course, is that if you have some client who's selling some fantastic strain of marijuana that they've invented and created, and they want to call it the Purple Haze Mushroom Special or whatever it's called, they can't get a federal trademark, but they should think about getting a state trademark. Now, the other practice pointer that you can tell your client is they can get federal trademarks for perhaps the ancillary goods and services they're selling from their medical marijuana dispensary that are not specifically the marijuana itself. So they may well sell a version of some clothes or keychains or even tobacco and tobacco-related products out of the dispensary under a brand, and so they certainly could get a federal trademark registration on that mark for that brand, so long as it's not for the purpose of, they're not trying to protect the sale of marijuana. As we turn to the next slide, staying with our drug thing, we can see the case of In re Kirby, where someone once tried to register the mark cocaine for an energy drink cola. And as they did this, they went to market with their cocaine energy drink, and the first federal agency to drop the hammer on them was the FDA for representations and issues with respect to the product and whether it really met the Federal Drug Administration labeling laws. They worked out their problems with the FDA. They thought they were good to go, and then the Patent and Trademark Office dropped the hammer on them and said, nope, cocaine, like marijuana, is illegal under federal law. You can't use cocaine for an energy drink because it's immoral and it's scandalous. And the opinion's fascinating. If you Google it, you can find the opinion. The serial number on the pending application is there. But essentially, it boiled down to the denial of someone using the word cocaine as it related to energy drinks, and they had drink recipes where you could mix the drink with alcohol to give one a great energy high or whatnot. And it just came too close to the line, the Patent Office believed, especially as it could have an impact on children. And so the mark was rejected and denied. It wasn't litigated further, and so First Amendment questions on this were never tested in the federal courts. But as it stands today, you won't find drug names on colas or energy drinks. Our next slide, we now move to marijuana device patents. And so here it's fascinating. There's no prohibition on receiving a marijuana-based patent per se, unlike the issue we had in the trademark space on marijuana as we talked about. And so this creates an obvious disconnect in the law. It's a disconnect that exists today. It will obviously be the subject of litigation as this gets worked out. But it's another example of how these lifestyle industries, the drug industries, are really pushing the boundaries of intellectual property law, where you're now seeing tension evolving between the patent and the trademark laws in terms of what can happen in the marijuana space. As you see here, there are a few, these are just exemplary patents I pulled to show you, but you have the first one, patent 9220294. It covers methods and devices using cannabis vapors. The next patent is actually for a cannabinoid patch and a method for transdermal delivery of cannabis. In other words, sort of the patch that you stick on the skin, and it allows slow release of cannabis and marijuana THC into the blood. And so you see some other patents here too. These are issued routinely. And as we turn to the next slide, we see it's particularly fascinating because just earlier this year in 2017, there was what looks like a marijuana device patent issued to, yes, none other than Apple. So the patent is for, as you can see the picture of it here, it's a sublimator or a vaporizer. And the language claimed by Apple is as follows. A chamber body is to receive therein a substance that is to be vaporized or sublimated into a vapor. A plate whose bottom face rests on the substance inside the chamber body is temperature regulated, e.g., using a heater therein, which releases heat directly above the substance that lies below. The plate slides downward as the substance is consumed by vaporization. Other embodiments are described. So the patent doesn't mention marijuana being the substance. It could be any substance, and it's not clear exactly why Apple is getting necessarily into the vaporization business, but one can only hypothesize and speculate that the medical marijuana space will be massive in the future, and so perhaps Apple is getting some patents to protect it in some way there. The patents could also have nothing to do with marijuana, but nonetheless, it certainly looks like a marijuana device patent that even Apple's getting into. To close out this thought as we move to our next slide, we can find that the law truly does create conundrums at times. Because here we have a marijuana patent that's been issued to and is owned by none other than the United States government. This is entitled Cannabinoids as Antioxidants and Neuroprotectants. You see the inventors were some physicians from Irvine and Maryland, and the United States of America, as represented by the Department of Health and Human Services, owns this patent. And what does the patent claim? The patent actually claims, as you see there in the language, a method of treating diseases caused by oxidative stress comprising administering a therapeutically effective amount of a cannabinoid that has substantially no binding to the NMDA receptor to a subject who has a disease caused by oxidative stress. So it appears the federal government issues patents to itself on the use of marijuana in a medical space. Meanwhile, it is illegal under federal law for state dispensaries to sell and transport the marijuana, even though they're doing it under state law. It's a riddle the law will have to solve, and it's a fascinating riddle that leads me to another example from one of my real-world cases in terms of the medical marijuana industry and advocacy that one can do for them. So here's the story of what happened, and the practice pointer will follow. Got a call one day from a client who was a medical marijuana dispensary in a local city here in California. The California Supreme Court had ruled that cities could zone out medical marijuana dispensaries. And so the day after the decision came down, they got a letter saying you need to shut down your medical marijuana dispensary within a few days. Client wanted some litigation advocacy really before the local city council and wanted lawyers who were not medical marijuana lawyers. They wanted litigators. And so they found their way to me and asked if I'd go effectively lobby on their behalf to buy them some time with arguments to the city council about, delay, give them a fair chance to relocate, et cetera, et cetera. So I said, sure, of course, happy to do it. Let me come see your medical marijuana pharmacy so I can explain to the city council that this isn't drugs, this is medicinal marijuana and all of that. So went down there, met with them, saw their pharmacy, was talking to the client, and we were sitting in the pharmacy, in their medical marijuana pharmacy, discussing how to do the advocacy at the city council and to see if we could buy them a few weeks or months breathing room. And as I was having the conversation with the client's phone rang, and the client said, "Oh, SHIT, oh, beep, beep, beep," other expletives. And then the client said, "Hold on, my lawyer's here, let me ask him." Puts down the phone and says to me, "Peter, our warehouse where we grow the marijuana that we sell here in the pharmacy is being raided by the Federal Drug Enforcement Agency. What do we do?" To which I responded, in my mind at least, I wish I'd taken criminal procedure law in law school and not only taken it from the bar. But I know the answer to this question. Tell him, Miranda, don't say anything, refuse to answer a question, tell him to cooperate, don't fight, don't resist, demand a lawyer, say nothing. They gave the advice, DEA raided the client's warehouse, at which point I realized to the client, advocacy to the city council is not a good idea anymore. Let's call a criminal defense lawyer. And a criminal defense lawyer was called. Practice pointer being, anytime you represent a client, as we've seen in the sex industry or in the medical marijuana industry, because of the confusion in the law today between federal and state law, they really do need to have criminal lawyers who they work with at any given time, because notwithstanding the legality of things under state law, the federal government, if it chooses, can come in and decide to prosecute and go after these state dispensaries. And it's an area of complete confusion. It's constantly changing, especially with administration changes. And so those clients definitely need to have criminal lawyers. And as a footnote, by the way, I left there thinking, thank goodness we didn't meet at their warehouse, because when the DEA raided it, they would have arrested me and I would have said, "But I'm the lawyer," and I probably would have spent a day or two in federal prison until they could figure out that really I was the lawyer. So good to have meetings not in marijuana warehouses. That's another side note. Let's now move from drugs to rock and roll. And here we're going to talk about copyright and plagiarism. And the famous case is the recent case of Stairway to Heaven. And this was a case from 2017 in the federal courts in Los Angeles. And I'm going to play for you a little clip right now that you can listen to. It's only 45 seconds long, but you can hear the clip of Led Zeppelin's song and then the clip of the song from the plaintiff, who had recorded a song 40 years ago and had toured with Led Zeppelin at the time. They played on the same stage, and the band claimed that Led Zeppelin's Stairway to Heaven, the introduction of it, borrowed heavily and substantially from their song. So here's the clip. Listen to this for 40 seconds, and then we'll come right back. So now you've heard the clip, and so you as the listeners can be the jury. Do you think that Led Zeppelin infringed on that piece of music? It's for you to decide. The jury, however, decided no, and they rejected the plaintiff's claim. The jury didn't actually hear those two clips as you heard them. The court had an expert come in and play the sheet music of the plaintiff's music and then Led Zeppelin's Stairway to Heaven. And there was substantial testimony and discussion about how, despite any similarities in the sound, the chord progression and the building blocks of the music were actually very, very common generic elements that were used in a whole range of music, even going back to classical music in the 1600s. And so the argument and the litigation centered around, can one monopolize a particular chord progression or particular sequence of music that is actually very, very common? And that is an example of where the copyright laws in the music space in particular, in the realm of rock and roll and Led Zeppelin, really test, often more than other areas of copyright law, the boundaries between what we talked about in the beginning of the program, the tension between giving just rewards to authors, such as the band that first came up with their riff that sounded like Stairway to Heaven, versus promoting the progress of the arts and the sciences by not allowing people to have undue monopolies on common building blocks and material that others can build on. And that tension was exemplified perfectly in this case involving Led Zeppelin. As a funny anecdote aside, this case occurred in federal court in Los Angeles before Judge Klausner, and quite literally the very week before, I was in trial in a case before Judge Klausner for a client in a related lifestyle industry, the hookah space, which is kind of part of the smoking space, although it's tobacco hookah, where we were in trial litigating trademark issues in the realm of hookah and hookah devices as part of the lifestyle space of hookah. So you have these cases landing in federal courts and federal judges who every day are dealing with these issues between them and the juries, having to really decide the outer boundaries of legal principles. In any event, the Led Zeppelin case is now on appeal in the Ninth Circuit, so stay tuned. We'll see what the outcome of that case is. This issue of copyright in music goes back to the 1970s even. And one of the very early cases, which is a fascinating case that resulted in an important doctrine of copyright law, again coming out of the rock and roll space that has broad application to all spaces, was the George Harrison case. And so you see here we're talking about his song, My Sweet Lord. And he was sued by Ronnie Mack of the Chiffons in 1963, who released a song called He's So Fine. And that's when the song was released. It had huge airplay in 1963. The Beatles were in the US touring at the same time. And then you fast forward 10 years and George Harrison releases My Sweet Lord. George Harrison denied any copying. But here you can listen to this little clip that we'll play for about a minute and a half of the two songs mashed together playing over each other, and you can see that there is in fact staggering similarities. So here, let's listen to this for the next minute or so.
Really wanna show you love, but it won't take long. She was mine, my sweet Lord. Right with the way. I don't know how I'm gonna do it, but I'm gonna make mine. Keep my hand
Okay, so there you heard the two songs played over each other. The court concluded, yes, George Harrison did infringe, but the court also credited George Harrison's assertion and testimony that he didn't sit down and with any conscious state of mind set out to infringe that song. What the court coined was the doctrine of subconscious plagiarism. The song had been played heavily, he was aware of it, it was in his mind, and it was just sat in his mind, and it came out years later. And this is an example of another important concept of copyright law that has been pushed by the music industry in terms of the scope of copying and what is infringement. Because you many times do have examples of people who do not have any malintent, who do not sit down with a design to steal someone else's work, but that work they've been exposed to and it's been seminal and it has affected them and it's worked its way into their consciousness, and later on when it comes out in a piece of music or in a piece of literature or in a sculpture or whatever it may be that your clients are doing, they may trip over the copyright lines. That brings us from copyright in rock and roll to where we're going to end the program today, and that is the rock and roll industry and trademarks on disparaging marks. And this case is the case involving the band known as the Slants. And so the story is as follows. It's a rock and roll band out of the Pacific Northwest, and the band founder is an Asian American man who named the band the Slants. And he did this as an act of reappropriation, which is, as I've explained here, is the concept of intentionally adopting a known demeaning or disparaging term aimed at a group, here the Asian American community, and then affirmatively wearing that previously sort of disparaging term as some sort of badge of pride in essentially seizing the bigot's language and reappropriating it to yourself. And so that's the concept and the idea, the social policy idea that underlay his wanting to name the band the Slants. He went to the Patent Trademark Office. Patent Trademark Office, based on that language we talked about earlier when we were talking about disparaging marks, refused registration and said that this is a mark that disparages persons, living or dead, institutions, beliefs, or national symbols. He took this on appeal to the Federal Circuit Court of Appeals, which in an en banc decision held 9-3 that no, quote, the First Amendment protects even hurtful speech, end quote. And so the Federal Circuit, as a result, allowed the trademark to issue. This then, the government took up to the United States Supreme Court. The United States Supreme Court heard oral argument in the beginning of 2017 before the 8 justices on the court at the time. And the government's argument, in essence, is that nothing in the First Amendment requires Congress to encourage the use of racial slurs in commerce. In other words, what the government was saying is that you want to receive a government benefit, such as the issuance of a federal trademark registration, then it can be subject to reasonable limits by the government to not allow you to receive that property right from the government when it is something that slurs or disparages others. The government wasn't saying you can't name your band the Slants, of course, because you can, you just wouldn't receive a federal trademark, you'd have state common law protection. Interestingly, the Korematsu Center and then the opponents of the Redskins trademark, the parties battling to take away the Redskins as a trademark by the National Football League team, they joined on the government side of this and really disagreeing with this concept of reappropriation in essence because of the damaging nature of it from their perspective. So you have these fascinating battles and these concepts of reappropriation, is it proper, is it not, underlying the decision, and of course the massive intersection of the First Amendment and trademark laws, really the most important First Amendment trademark case in the last generation. Oral argument was very, very spirited. It looks like it may be a split decision, and we now have to wait to see what happens. But curiously, if it splits 4-4, then the Federal Circuit's decision would stand under Supreme Court rules in terms of what happens when you have split decisions at the Supreme Court. And so the First Amendment then would allow this mark to register. This then would have massive implications for your clients, even if they're not in the rock and roll space or the sex or drug space. The implications are staggering for all businesses then. This brings us then to our conclusion of sex, drugs, and rock and roll. The key conclusions that I hope you walk away from are listed here, and they are that intellectual property law touches all facets of a small business. If no matter what your client is doing, if it's involved in business in any way in commerce, it's using a trademark or a brand, it probably has advertising material or a website, which would be potentially trademark and copyright material, and it may make a product which is subject to patent laws. So constantly be aware of IP law and how it affects all facets of your client's business. The second important point is that intellectual property law is really being tested and pushed by these modern lifestyle industries. And this ripples over to regular businesses. So even if you don't represent clients in the sex or the drugs or the rock and roll space, no matter how fascinating and fun it can be at times, I must confess, even if you don't represent them though, you must be aware that the decisions coming out of those industries have broad implications. And so this gives your clients business opportunities to consider pursuing, and it also means that your knee-jerk reactions about what's doable, what's not doable under the law may well be wrong, and your knee-jerk reactions are going to be tested by those who are in industries that may make one uncomfortable and squeamish at times. The final point is, and as you've seen in a couple of my examples, is that when dealing with potentially controversial issues, medical marijuana, adult industry, even it starts getting into online dating, just anything that could be potentially controversial, dealing with people, relationships, sex, drugs, even rock and roll at times, as we saw, you must be extra cautious and cognizant that you have not only intellectual property laws that are at work, but there are significant and important criminal laws that overlay these areas and intersect heavily in these areas. You need to be aware of them. You need to be in communication with criminal lawyers who can help your clients also. Thank you very much for this presentation. I hope you enjoyed it. Again, I'm Peter Afrasiabi from the law firm of One LLP, and all of these views on sex, drugs, and rock and roll are mine and mine alone. Thank you.